Good morning, everyone. It's Carol Williams with Williams Immigration, and we are back for another Monday episode of Beyond the Soundbite, where we talk about immigration issues a little bit more in depth than what you may get on the 6 o'clock news. So we try to go beyond that 20-second soundbite and talk about what's happened in immigration the week before, what's hot, and how it impacts you. So this week is definitely no different. So there has been quite a bit going on. So here's what there are several things I want to talk to you about. And if you have never tuned in, I'm Carol Williams with Williams Immigration. So here we go. So last week, October 13th, was the last day to file your adjustment of status application without the form I-944, which is your affidavit of sufficiency, which tells the Immigration Service where you stand on the public charge spectrum. And that's what they're using now to determine whether or not you will be a public charge. So if you filed your adjustment of status before October 13th, the Immigration Service will issue you an RFE for your I-944, your affidavit of sufficiency, and all the supporting documents. So moving forward, it is super important to remember that you must include the 944 because it is now fully required, and the USCIS website is updated to reflect this new requirement. So the other thing I wanted to talk about when we're talking about green card applications and adjustment of status applications, the question I often get is, but Carol, how long is it going to take for this application? Because this is the last application before the green card is issued. So I looked at all the major service centers, especially if you are an employment-based green card. The time frame, and this is across all 4 service centers, ranges from 8.5 months to just about 2.5 years. So we're looking at a fairly long time for you to get your green card application. So it's super important that we file all the documents that we need, and that you bring into this process, especially this last part of the process, a very realistic expectation of how long this last part of the process is going to take. But I always tell my clients, hang in there. We're gonna make it happen. The other thing I wanted to talk to you guys about today was last week we talked about the proclamation that limited J1s, H1Bs, H2Bs, and L1s from entering the country. We do know that we have a very limited injunction from the courts on that. And last week we talked about how the Department of State has told its consulates do not take that proclamation into consideration because of the limited injunction. So it's really important to remember that while you are outside of the country, while your employee is outside of the country, Department of State is certainly going to follow the rules, but remember, many consulates are still not up to speed 100% because of the pandemic. So they are operating with very limited hours. Some are only processing emergency cases. So just keep that into consideration when you are planning to have your beneficiaries come into the United States. The proposed rule to collect more biographic information, we have definitely talked about this on our Monday mornings here on Beyond the Soundbite. So we've just reached a critical point in that proposed rulemaking, and that is the public comment period is now closed. So now the government's going to evaluate all of the comments that it receives and decide if, based on some of those comments, it will amend the rule in any way, shape, or form. So remember, that rule was to expand the type and amount of biometrics that are taken. They currently do not take biometrics from U.S. citizens. Part of that rule is to expand into taking biometrics from US citizens and anyone related to the application. And the biometrics would now be expanded to include not only your picture, not only your fingerprints, but they also want to add in iris scans, palm prints, voice print, as well as DNA. So I suspect the comments to this new rule were quite robust. I suspect they also talked quite a bit about privacy concerns and who would be taking the biometrics, where the biometrics would be stored, how long they would be stored, and any sort of adverse implications of taking those biometrics. So I will keep y'all up to date with this proposed expansion of biometrics. The next thing I want to talk to y'all about is the EVerify. So we haven't talked about EVerify yet on our Monday morning beyond this soundbite. So EVerify, if you're unaware, it is an online system which allows employers to confirm an employee's identity and eligibility to work in the United States. So EVerify pings data from DHS, Department of Homeland Security, as well as the Social Security Administration in its evaluation of someone's identity and eligibility to work in the United States. It is super important to understand about EVerify that it is not a substitute for completing the I-9. If a company chooses to enroll in EVerify, they still must complete the I-9. So just keep that in mind. So last week, the Immigration Service said that they are going to start reminding employers who have enrolled in EVerify that they have to take action on tentative non-confirmations within 10 federal government working days. And so this reminder, we're not quite sure how gentle it will be. We're not quite sure what form it will arrive, but they're going to remind employers that they really need to be taking action on tentative non-confirmations within 10 government days. So a tentative non-confirmation is when you submit the information to EVerify, and EVerify comes back and says, you know what, we can't quite confirm this person's identity or their ability or their eligibility to work in the United States. And, you need to give the employee a chance to give you the proper documents and see what the problem is. That might mean they may need to have a conversation with Social Security. It could mean, that they need to have a conversation with the Immigration Service because maybe documents were not loaded properly from either one of those agencies. So it's really an opportunity for the employee to figure out what's going on within the online systems and get that fixed for themselves so that they can show the employer that they are in fact who they are and that they are eligible to work in the United States. So just remember, you've got 10 federal government working days to have a conversation with your employee so that they are starting to work on the tentative non-confirmation, and so that they're aware of it. If it's a simple technical error, if they're not aware of it, they can't have it fixed. So that's super, super important that we work on that. So that is our EVerify update, and I'll be bringing you more EVerify and I-9 updates, and I'll be putting more of that information also in my newsletter. So if that's something that you're interested in or you want to learn more about, feel free to drop your email address in the comments and I will add you to my newsletter, or you can certainly shoot me an email or shoot me a DM and I will be more than happy to add you to my newsletter where we get a little bit different information than what we do here on our Monday mornings beyond the soundbite. Premium processing. So we had another what I call Friday surprise from the Immigration Service. So we knew that there was a new law that passed October 1 that expanded USCIS's use of the premium processing service to other eligible case types, as well as increased the fee from $1,440 to $2,500. Before Friday, we didn't have a sense of when they were actually going to implement this new rule. Well, Friday afternoon, they said, well, we're going to start implementing on Monday. Just a part of it, but we're going to implement on Monday. So as of today, any applications filed using premium processing, the new fee must be submitted. And so that new fee is $2,500. So for any applications that are currently eligible for premium processing, the new premium processing fee is $2,500. H2Bs and R1s, however, their premium processing fee will increase to $1,500. So their premium processing fees for H2Bs and R1s are not going up significantly, but the premium processing fee for all other applications that are currently eligible for premium processing are going up to $2,500. And so I know that we've talked about fees a lot. I'm going to continue to talk about them. So remember, the increase in the premium processing fee was not a part of the larger overall rule that the Immigration Service put out to increase all of the other application filing fees. That rule has still been enjoined by the court. It is still stopped. That rule is still not active. So all of the other filing fees for immigration services remain the same. It is just the premium processing rule that has gone up. So those are the updates that I have for you and how they impact you this Monday morning for Beyond the Soundbite with me, Carol Williams of Williams Immigration. So if you found this helpful, or you have any questions, please feel free to drop a comment. If you're watching this on the replay, please feel free to put #replay, and I will be happy to go back in and respond because I do look at those. And again, if you want to be added to my newsletter, feel free to drop your email address in the comment or in the DMs, and I will make sure that you get added. So again, happy Monday. This is Carol with Beyond the Soundbite. Talk to you next Monday.